Mr. Gary has my selection.
All right, and so that the record can be clear, the court is aware of who can and cannot appear by Zoom and who the court gave permission to appear by Zoom and not by Zoom. So there's no need to come in hot with, you told her she could appear by Zoom. I already know that it's on the docket sheet. The Zoom link changes and it changes every single month. The clerks in the back do not have the Zoom link. Once they come out here, that's when they're given the Zoom link. So where are we on discovery?
Well, Judge, may I respond? Because I think
No.
that it is, well, it.
Where are we on
I
discovery?
think that is.
Where are we on
I
discovery?
I think, Judge, I feel like you don't want to hear the response, but it's important because this happens to people. What happened was I came yesterday, I wanted to get the Zoom link. I actually checked.
I don't give the Zoom
they
link
checked-
the day before.
Yeah, they checked the docket.
I don't give a Zoom.
They said there was
It
no.
has Zoom reading right there. You see that on the docket? What does it say? Zoom. You know what that means?
But then the
That
court
means
issued a
that
bond
your client,
forfeiture.
I have not issued a bond forfeiture.
On the video.
All right,
it
so
was
here's
my
the
client.
thing. Where are we on discovery?
Discovery Judge, it's Northeast Methodist Hospital. It was requested. We looked, when we went up during lunch, we have not received those records from the hospital. So they're not in our possession at this point.
So when will you have those? Because we've been waiting
It was
for a while.
Sorry to interrupt. They were supposed to be here. I think the subpoena has mentioned September 25th. If I'm incorrect. I don't know, but they were supposed to be
You're
here.
correct, because it's on the docket.
Okay, and we don't have them. So they're not in the state's possession at this point. And when we were during the lunch break, I had the discussion with my investigator to hunt those down, and we're probably gonna have to request them again. I just don't know why that they have not responded.
All right, so what I have is the outstanding medical discovery, and it's your client's discovery. Miss Malik, if you can start your video, please.
She's been trying to juggle a bunch of stuff. She's been on and off since she got the Zoom link, so.
Do you have her, this is your client, correct?
It is.
Okay, could you unmute for me, please? All
Yes,
right.
ma'am.
What I have is outstanding medical records of your client, and the state was to upload. Is there different medical records that we're looking for?
Judge, what we're looking for is there was an emergency detention on the
Mhm.
day that my client got taken into custody, so they are trying to get the police / you probably hospital / court document / all of that should be in those medical records. So we're trying to get those.
All right, so do y'all know maybe if, usually those records, if she was taken into custody and then had the emergency detention, sometimes the sheriff's office may have them in their records potentially. And when I say the sheriff's office, I mean their health department, their infirmary. So they may have it.
Right, sometimes university has the beginning ones, and I think that's what we're trying to look for.
I guess, I mean, they're actually, I mean, I was unaware of I might have been before of its discussions, but I'm not remembering independently. But the only thing that I've seen that we requested is Northeast Methodist Hospital records. But if they took her into custody or emergency detention, there should be a report. So
Yes.
I don't know if that report's in the file or not, but.
The police report's in the file, and I know just you have a million cases and that this one is, I know you know a little of it, but it's in the police report that's what happened, and that's why we're trying to get that.
So do y'all think they may have it at the sheriff's?
It could. I mean, if it says in the police report, emergency detention judge, that might be what they used. And then any type of document, like the page, whatever that they fill out when they take her to the hospital, it would be at the hospital. And I don't know if they retain that or not, but as far, I mean, I don't.
Be to Mr. Edelman to do that, so,
Okay, that's CPS.
yeah.
All right, and what I can tell you too, if that's the when you say CPS, you mean Child Protective Services? All right, has anybody looked at that? Because sometimes if there's an emergency detention, they will have it in the CPS records as well.
They have a USB. I don't have the full copy of that. They probably, I'm guessing, have part of it, and then we're still gonna need, the rest, but yeah, I think that's a good starting point.
All right, so this is what I am going to do.
Oh, I don't know if it's uploaded. I saw a NOAD and I saw something else that was uploaded in the NOAD.
All right, so we're gonna recall this back on November 21st to see where we're at by discovery.
Okay.
And so if you all can look in once you get the CPS records, look in there and see if it's there. And if somebody can check with the jail to see if they have any documentation.
I'm gone that week, Judge,
Mhm.
like, and so is there, if I can't, I mean, if you're fine with me appearing by Zoom, I can appear by Zoom, I mean, but I'll be out of state, I have a wedding on the 22nd, I think that's a Thursday, I have a wedding on the 2nd, so if you could do it either the week before or the week after
We can bring it up
Thanksgiving.
on the 14th.
Okay, we can try for that, that's perfect.
All right, so we're coming back on the 14th.
And are we still muted? Can we be muted?
Sure, let's, just 1 second.
But I believe we do have the medical records and I believe we do have the CPS records in here.
Oh,
Well, if you do, that's great.
Just, I mean, and
That's a good start.
that's why, because I did mark on here and I checked off that we have the CPS records and the emergency detention or medical records. I believe that because this envelope that I just showed to the court and defense counsel, it was not opened.
okay,
And
so,
so, and I believe it's patient, so I believe we have both. And
all
I
right, so
just-
then what
so
we'll
just
do
hard
then
drive
is,
Well,
from
we-
the defense.
state, you'll need to, we're gonna reset this to December 2nd and state you need to be prepared to tender an offer on that day.
Yes.
All right.
And I'm gonna look at this, Judge, and I'll let you know, because I think if it doesn't have the court stuff and everything, I will let them know, hey, there may be some other, because I think that if it is an ED, there should have been a court order, and if the medical has it, they have it, but I also kind of want to see the court stuff, so I've asked them to see if they can possibly look into that as well.
All right, we'll come back on December 2nd. State at that time, you need to be prepared to tender our offer.
All right, good.
Okay, perfect, thank you.
And hey, Chairman,
And Miss Malik, where are you at? Are you in Bear County?
Yes, ma'am.
All right, so then since December 2nd date, that's the date that the state is going to tender an offer, you'll need to be in court on that day, okay?
Yes, ma'am.
All right, and that'll be at 9 a.m.
Yes, ma'am.
All right, thank you. You can be
Thank you.
excused now.
whatever.
I think it-
All right, YADHIRA, Romo? Norma, does somebody want to grab Anthony Cantrell in the hallway? Because they just brought his client out. Yeah, I think he went in the back hallway or something. Court is calling 2024 CR 3657, State of Texas versus YADHIRA, Romo. Can I have parties announced for the record for the state?
Andrew Harris, Adler.
Defense?
Renee Munoz.
Are you Miss Romo? You need to speak up.
Yes, ma'am.
Counsel, have you received all of the discovery?
Yes, Your Honor.
Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Did you understand in count 2, you're charged with manufacturing, delivering a controlled substance, penalty group 1 gram to 4 grams. That's a 2nd-degree felony.
Yes,
I'm sorry.
yes, ma'am.
Shouldn't this be a 2nd degree? If y'all are doing it as a manufacturer,
Actually knowingly possess.
oh, you all have it listed as the offenses, manufacturing and delivery.
That is my mistake, Your Honor. If you'll allow
Sorry
me
about
to
that.
correct it.
Sure, no problem. All right, so count 2, they are proceeding on it as just a possession. You understand?
Yes.
So then that's a 3rd-degree felony, and they're just changing the paperwork to notate it as possession and not manufacturing and delivery.
Okay,
So the range of punishment for that offense is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $1,000 fine to be probated. The state is proceeding on count 2 only, and they're recommending deferred adjudication. Did you understand that to be the plea?
Yeah.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 10 years. There be a TAP evaluation, 120 hours of community service restitution, and a drug court evaluation. Then to the offense as charged in count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
If we may, Your Honor.
Anything you wish to say on behalf of your client?
Briefly, Judge, my client's currently 21 years of age. She's been on bond for this offense since March. There's been no violation reports filed. She's also had no positive drug tests. She has been tested negative. I asked my client if she explained she used marijuana a few years ago, but nothing recent. I asked if the court asked her to take a drug test today, what would the results be? She maintained they would be negative, Judge. She doesn't use any substances. She's been successful while on bond. She explained to me that at the time of this offense, it was a bonehead move, trying to make a quick buck. She's remorseful for that, Judge. And I think the state offered deferred for that reason in terms of her age, which you accepted. We're asking a 10-year term. This is quite a long time. The court would consider anything less. She has not gotten her GED, Judge. She didn't complete high school, but I highly encouraged of that of her, and we're asking if the court can place that as a condition so she can work towards that and better her life, Your Honor. But with regard to that, she's just asking for a chance from this honorable court. In terms of the substance, she didn't know what the substance was. She thought it was oxycodone, the M30s. She wasn't even know what the other substance came until I explained it to her within the charge, Judge. So we're respectfully asking that we follow the plea bargain agreements, and she's willing to abide by those conditions as stated for the court.
All right, do you have any children?
Don't.
All right. Who do you live with?
My mom and my dad.
All right. Any children in the household?
My nephews,
All right, and what are their ages?
ages 6 and 5.
How long have you been living with your parents?
Since I did move out at one point, but I moved back in. So
Are you employed?
no, not right now.
So why are you not employed? And how long have you not been employed?
I'd say a year now. It's kind of hard for me to get a job
Why?
with the charge that I have right now.
Okay.
And they do background checks. So anytime they do a background check, it just pops up. And, but yeah,
All right, and what's with the tattoo?
just a tattoo I decided to get,
Why?
because I wanted to.
And what does it mean?
The one on my face.
Mhm.
It's just a broken heart.
And what do the other tattoos mean?
Nothing really, is just drawings that I like and decided to get also.
This is what the court is going to do. State, did you want to address the issue? Defense is asking for less than 10 years on probation. And how much are you asking for, counsel?
The court could impose perhaps 7 or 8. She understands it's a significant charge, Judge, and she's willing to atone. But a decade seems.
So defense is asking for 7 or 8 years on deferred adjudication.
Your Honor,
Yes.
there's no objection from defense counsel. May I provide Ms. Romo's criminal history.
Yes. Any objection?
No objection.
May I approach, Your Honor?
Yes.
Thank you.
And I know y'all are asking for felony drug court, but they're not going to accept her due to the nature of the charge.
Okay, Judge. I'll make it.
All right. I'm going to set her deferred adjudication at 10 years. If she completes everything early, the court will consider early termination, but no sooner than 5 years.
Yes, Judge.
So there's $1,000 fine that would be probated, 10 years deferred adjudication. Proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. And when you're drug tested today, what are the results going to be? And mind you, I'm asking you not to punish you today, because if you use, you will not have violated your probation because you were not on probation. I'm trying to see what conditions to give you. So you need to be honest with me. When you're drug tested today, what are the results going to be?
It would be negative.
All right. I'm going to want a drug test. We'll have felony drug court drug test you today. I'm going to ask for 300 hours of community service restitution. You may be excused.
Thank you, Your Honor.
100 hours of those will be waived upon completion of her GED, or either if she completes some sort of trade school. There's to be regular reporting by Zoom or in person, regular random UAs. And also, counsel, if she were to complete college, if she wants to go to college,
Yes, Your Honor.
then the 100 hours will be waived.
Yes, Your Honor.
I'm going to want field visits 1 time per month for 6 months. There's to be no unsupervised contact with minors. So that means that your parents cannot use you as a person to babysit your niece or your nephew. You understand?
Yes, ma'am.
And are they in the home because of CPS?
No, my brother lives there.
Okay, I asked you who all live there and you just said your mom, your father, you, and your niece and your nephew. You didn't say anyone else.
I didn't say that.
No, you did not.
I'm sorry about that.
You left out your brother? Is
Yeah.
that what it is?
So
Okay.
anyone else other than your brother?
No.
And where are the mother of the niece and the nephew?
She doesn't live there. They're not together.
Okay. So I'm telling you right now, if CPS is involved and you're not supposed to be there, they're going to end up removing your niece and your nephew. You understand?
Yes, ma'am.
Yes, let's do a TAP evaluation, and that can be out of custody,
Yes, Your Honor.
and follow TAP recommendations. And if TAP is recommending inpatient treatment, we'll start first with intensive outpatient treatment. Anything else, probation? Is there anything else you need from the court in order to be successful?
No, ma'am.
All right, we can go off the record. In this court, in order to be successful on probation, communication is key. If you have an issue, let your probation officer know. If you feel as though they're not addressing that issue, you can always come back to court. Do you understand?
Yes, ma'am.
And from here on out, everything that you do, you need to ask yourself, what I'm doing, could this potentially result in me going to prison for 10 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. You understand?
Yes, ma'am.
All right, good luck to you. Probation will go over conditions.
Okay, thank you.
Thank you, Your Honor.
You're welcome.